Good morning everyone, thanks very much for joining me in the latest Lawshare Q&A. I'm very pleased to be joined by Technical Manager from leading cost lawyers Kain, Ged Kourtney. Ged, thanks ever so much for joining me. Well?
Thanks for having me. Yeah, very good, thank you.
Excellent. Okay, so Ged and Kain have been involved in the Belsner Appeal, which for our members practicing predominantly in personal injury work will probably be aware of this very significant case that's gone all the way to the Court of Appeal. So Ged, the Belsner Appeal, this particular case, been rumbling on now for a number of years. Do you think you might be able to provide us with a little bit of a potted history of the case and sort of where we're up to now?
Yeah, of course. So Belsner relates to the interaction between two rules, one civil procedure rule and one statutory rule. So section 74(3) of the Solicitors Act says that a solicitor can't charge their client more money than is recovered from a third party in the litigation. And CPR 4692 says that 74(3) can be disapplied in circumstances where the solicitor and their client have entered into a written agreement that expressly provides for that rule to be disapplied. So Belsner and Cam Legal relates to a dispute between a solicitor and their former client about a sum of money deducted from the client's damages at the end of a personal injury claim. It was £385.50 was the amount that was deducted. Okay. The claimant made no complaint at the time the claim settled, but sometime later brought a claim against Cam Legal Services via Section 70 of the Solicitors Act. That was issued in the High Court in Sheffield and was ultimately heard by one of the district judges there, who found that there was a written agreement in place sufficient to satisfy 4692 and therefore disapply any limitations that 74(3) would impose. The claimant solicitors, the client solicitors were not happy with that outcome, and the matter was appealed to the High Court, where Mr. Justice Lavender decided that whilst the language of 4692 didn't expressly require informed consent, the fact that the relationship between a solicitor and their client was a fiduciary one meant that informed consent was a precondition of satisfying that rule. So the effect of that decision was to limit the basic charges to the sums that were recovered from the third party, which, with this being a fixed costs matter, was about £500. Understandably, the claimant solicitors, or should I say the solicitors, were not happy with the outcome of that decision and sought leave to appeal to the Court of Appeal, which is essentially where we are now. In addition to arguing that there was a written agreement so as to disapply 4692, the solicitors also sought to resurrect an earlier point that had been argued before the district judge, which was that Section 74(3) didn't apply at all, on the basis that this related to non-contentious business in relation to a non-litigated matter, essentially. So the arguments that are present essentially is, was informed consent, was Section 74(3) engaged, and if it was there an agreement in place to satisfy that rule?
Okay, great. So informed consent obviously plays a significant part in this particular appeal, but by the sounds of things, there's sort of wider implications at play. Is that right?
Yeah, precisely. So it was understood, or at least we understood it to be the case, that the distinction between contentious and non-contentious business was largely settled law. We thought that cases which settled prior to the issue of court proceedings would be considered non-contentious business, and as a consequence of that, there's a strong argument to say that the rule is not even engaged at all, which is obviously the starting point of the appeal. If the court is satisfied that 74(3) is engaged, then we move on to whether or not there's an agreement in place, or whether informed consent is required for there to be an agreement in place to charge more than was recovered.
Right, I see. So we're at the Court of Appeal. Clearly you wouldn't be running the case if you didn't think there was merit in it, but how do you see things going?
Well, as I said before, I think it's relatively settled law that cases that settle without court proceedings should be treated as non-contentious. And that would be a fairly strong argument to say that the rule doesn't even apply. And as you alluded to, it's our appeal, so we clearly think there's some merit in bringing it.
Yeah. Okay, great. And what's the potential fallout and from this, from the judgment, from the result of this appeal, and who's it most likely to impact?
Well, there's a variety of potential outcomes depending on which facets of the respondent's arguments are accepted, or if indeed any of them are accepted. If the appellant is successful, i.e. the firm of solicitors, if they're successful, then there isn't a great deal of work that needs to be done by those practicing in personal injury matters. However, if the court, for example, were to find that matters that settle in the pre-action protocol are contentious business, that could have serious implications for any business that conducts litigation on contingency fee agreements, because of the certain prohibitions in place for using those sorts of funding arrangements in non-contentious business, in contentious business. Essentially, if the claimant is successful on their primary point, i.e. that there's a requirement for informed consent, that they argue essentially that not only are you obliged to set out to your client what sort of fees you intend to charge them, but also what sort of fees you expect to recover from their opponent, which is incredibly difficult and will be increasingly difficult as fixed costs are expanded into wider areas such as more broader civil litigation and clinical negligence.
Well, it's a very interesting and important case, and we will all wait with bated breath for the result of it, especially our members at SA working in personal injury work, and as you mentioned there, it might have wider implications still across the legal sector. So yeah, very much look forward to catching up with Ged and his colleagues at Kain in the future to find out the result of this. Do keep an eye out for a webinar where we'll look at the result of this. And Ged, if I can thank you again for sparing your time and your insight, it's been really useful, and yeah, I'm sure that our members will find it incredibly helpful. If you do have any questions, you know the email address, lawshare@jmw.co.uk. Do come to me. The rest of the team will be happy to put you in touch with the experts, Ged and Kain. Ged, thanks again.
Thank you.